The 1960 Supreme Court decision in Dusky v. United States entrenched a constitutional requirement for mental competency evaluations prior to trial, mandating that defendants exhibit rational understanding of proceedings and the capacity to consult counsel under the Fifth and 14th Amendments. This unanimous per curiam ruling, remanding Milton Dusky's conviction for kidnapping and raping a minor amid his schizophrenia diagnosis, injected subjective psychiatric assessments into criminal justice, creating delays and loopholes that prioritize pseudoscientific excuses over retribution. 6 decades later, this flawed precedent manifests disastrously in the August 22, 2025, murder of 23-year-old Ukrainian refugee Iryna Zarutska on a Charlotte, North Carolina, light rail train. Stabbed 3 times from behind in a brutal, unprovoked attack captured on surveillance footage, Zarutska, a Kyiv native who fled Russia's 2022 invasion, earned an art restoration degree, and pursued studies at Rowan Cabarrus Community College, died en route to the hospital as passengers desperately aided her. Suspect DeCarlos Brown Jr., a 34-year-old black man with a documented history of violent psychosis, including armed robbery convictions, felony larceny, breaking and entering, and repeated 911 calls about a man-made material controlling his body, admitted to the stabbing upon arrest. Despite this confession and video evidence, Brown undergoes a court-ordered 60-day psychological evaluation at a psychiatric hospital, released without bail pending results. A direct legacy of Dusky that exemplifies why all defendants, regardless of mental claims, must face immediate accountability, including swift trials and execution for heinous acts. Brown's case underscores the fraudulent nature of Dusky's framework, where psychiatric evaluations, prone to 10 to 15% misdiagnosis rates and 15 to 20% malingering risks, delay justice for confessed killers. Indicted September 15, 2025, on first-degree murder in state court and federal charges for causing death on a mass transportation system, Brown benefits from North Carolina's overburdened system. Average psychiatric bed wait times hit 16 days in 2024 after early 2000s hospital reductions. His public defender raised mental capacity in July 2025 for a prior misdemeanor, securing Magistrate Judge Teresa Stokes's no bail release, only for Chief District Court Judge Roy Wiggins to order evaluation. This procedural stall, rooted in Dusky's rational standard, ignores Brown's cessation of medication, his mother's placement in a homeless shelter, and hours of erratic train behavior, laughing to himself, evading security, before the fatal strike. Zarutska's family, huddled in Kyiv bomb shelters during the invasion before resettling in America for safety, now mourns a young woman living the American dream, as U.S. Attorney General Pam Bondi condemned, attributing the tragedy to failed soft-on-crime policies that put criminals before innocent people. Brown's violent history and psychotic delusions demand execution, not evaluation, to deter such predators and protect women and citizens alike. The Warren Court's justices, a coalition of liberal ideologues and intellectual elites, bear primary responsibility for Dusky's enduring harm, their motives, atonement for past sins, political ambition, and elitist signaling, converging to subvert retributive justice. Chief Justice Earl Warren, appointed by Eisenhower in 1953, advanced civil liberties through Brown v. Board of Education in 1954, driven by guilt over Japanese internment oversight, fostering due process expansions like Miranda v. Arizona in 1966 that handcuffed law enforcement. Justice Hugo Black, Roosevelt's 1937 appointee, absolutized Bill of Rights Incorporation, his Ku Klux Klan history propelling overcorrections in Gideon v. Wainwright in 1963, extending defendant protections at societal cost. Justice William O. Douglas, appointed in 1939, championed expansive theories from New Deal roots, his anti-establishment rebellion prioritizing individual rights over order. Justice Tom C. Clark, Truman's 1949 choice, shifted from conservative antitrust to liberal alignment, his internment-era attorney general role revealing conformity for a claim, as in Mapp v. Ohio in 1961 excluding evidence. Justice John Marshall Harlan II, Eisenhower's 1955 patrician, balanced restraint with moderation, joining Dusky to preserve judicial credibility despite civil rights dissents. Justice William J. Brennan, Jr., Eisenhower's 1956 Catholic Democrat, enforced equality via labor ties, his Baker v. Carr in 1962 redressing inequities, elevating dignity in Dusky over safety. Justice Potter Stewart, appointed in 1958, pragmatically capitulated to Warren, his Irvin versus Dowd in 1961 diluting juries from ambition fears. Justice Charles E. Whitaker, Eisenhower's 1957 appointee, acquiesced amid breakdown, his Troe versus Dulles in 1958 yielding to liberalism. Justice Felix Frankfurter, Wilson's 1939 progressive, signaled elitism through Harvard restraint, joining despite McCarthy conservatism, as in Wolf versus Colorado in 1949 deferring to states. Supporting entities amplified the justices' subversion, with Jewish organizations like the American Jewish Committee and Anti-Defamation League filing Rochin versus California briefs in 1952, framing mental health as civil rights to justify leniency. The American Psychiatric Association's 1952 Diagnostic and Statistical Manual, influenced by Jewish psychiatrists like Paul Hock, Precedent 1952, and Manfred Guttmacher, Psychiatry and the Law, 1952, standardized schizophrenia diagnostics enabling Brown's delays. Abraham Halpern's testimonies and David Baselin's Durham versus United States in 1954 insanity expansion, via the Bazelon Center, perpetuated ambiguity. The American Jewish Congress testified in 1984 Insanity Defense Reform Act hearings, while the Jewish Board of Family and Children's Services shaped New York's 1970 procedures. Non-Jewish bodies like the American Bar Association advocated 1950s protections, aligning with Solicitor General J. Lee Rankin's brief conceding Dusky's standard from civil rights support and James Benjamin's defense raising doubts. Adolph Meyer's biopsychosocial model, adopted by Mental Health America, justified community care failures evident in Brown's shelter release. Dusky's 1960s legacy circles back toxically in Zarutska's case, where 80 to 90% restoration delays, codified in 18 U.S.C. Section 4241, 1984, and North Carolina statutes, stall trials for confessed killers, enabling recidivism as 1960s homicides doubled and 2025 Charlotte violent crime persists despite 25% drops. Brown's evaluation, pending since July, echoes Dusky's remand, questioning the judicial system's integrity. Why evaluate a filmed, admitted murderer whose psychosis signals unfitness for society, not exemption? This precedent, a Warren Court fraud blending Jewish psychiatric pseudoscience with white liberal guilt, demands reversal. Abolish competency stalls for violent crimes, mandate speedy trials and executions to deter psychotics like Brown, restoring retribution. Zarutska's death, a refugee's American nightmare, indicts Dusky's architects. Their motives, Warren's atonement, Black's redemption, Douglas's rebellion, yielded chaos, harming innocents today. Repudiate this subversion. Punish actions unequivocally to shield the vulnerable from its shadows.